Welcome back. Let's now turn our attention to the other big debate that we are taking up today. Now, the Bhima Koregaon case, in which 82-year-old Varavara Rao has finally got bail on medical grounds by the top court. Questioning the NIA's investigation, the top court said that Rao had been lodged in jail for 2.5 years, and yet the trial hadn't even begun. The bench also observed that charges are yet to be framed, even though a charge sheet has been filed. Meanwhile, the NIA strongly opposed the bail, saying that the age or medical condition cannot be a factor to let a UAPA accused out on bail. Now, this case, remember, relates to alleged inflammatory speeches made at the Elgar Parishad conclave held in Pune on December 31st, 2017, which the police claimed triggered violence the next day near the Koregaon Bhima War Memorial on the outskirts of the western Maharashtra city. The Pune police also claimed that the conclave was organized by people with alleged Maoist links. Let me, in fact, welcome our guests who are joining us: Sanjay Hegde, Senior Advocate of the Top Court, and Namit Saxena as well, Senior Advocate, Supreme Court, will be joining us as well. Mr. Hegde, if I can start with you first, your reaction here to this entire case and the fact that the Supreme Court has pointed out that here is again a case where for 2.5 years this man has been in jail and the trial hasn't even started.
Well, that's exactly the point of UAPA, isn't it? That you get to lock somebody and throw away the key.
Yes.
And this is a classic example. The UAPA has certain very harsh conditions for bail, and bail is not normally granted. There is also a judgment of the Supreme Court in the Vatali case, which says that, you can't even arrive at a prima facie satisfaction that there is no case to answer. So if the government of the day thinks that it is a fair law to just lock people away forever and say we will not hold trial please await your freedom till the trial concludes, then obviously courts have to find ways where the rigors of this law can be mitigated. Now you have an 82-year-old man who has incipient Parkinson's. I don't know whether you know what Parkinson's disease is.
Yes.
And how degenerative it gets.
Yes.
I can speak from personal experience of somebody within my family who had it. And people just can't take care of themselves as the disease progresses. They have to be helped for everything. And my brother, who's a doctor abroad, told me that at the end of the day, all that happens is that that some random infection or the other takes over either the lungs or any other organ, and it leads to multi-organ failure. So, in effect, what the prosecution was telling the court was that don't give him bail on medical grounds. Let him stay inside. And like Father Stan Swami, who died in prison, let nature take its own course. Oh, trial, we are not obligated to conduct a trial.
Yes, absolutely. Namit Saxena, your first comments here as well, because obviously it then keeps coming back to UAPA and, the way it's used and the stringent provisions of the UAPA.
See, Section 43D5 of UAPA makes bail extremely stringent. This is correct, because there is one reverse onus. Second, what 43D5 records is that there has to be an opinion of the court which grants bail, that that there are reasonable grounds for believing that the accusation is prima facie true. Now, this burden is extremely harsh, because to record that the accusations against a particular accused prima facie are true, without conducting a trial, without taking evidence on record, this is something which is extremely difficult for the trial court to do. So that is why the bail becomes extremely difficult in UAPA cases. As Mr. Hegde also pointed out, the Vatali judgment rather makes in fact I wrote an article on this saying that that you have outshylocked Shylock by through the Vatali judgment. So that has made it rather difficult. But in Varavara Rao's case today, what has happened is the Supreme Court looked at the medical conditions of of the accused. The Supreme Court found that that here is somebody who's 82 years of age. He has already been incarcerated for a considerable period of time. There is no custodial interrogation which is required anymore, as charge sheet has been filed. So why should he face the rigors of incarceration anymore? Why can't he be shifted out of the jail, and at least, and they have made sure that, that he presents himself during the trial by saying that he will not leave Greater Mumbai without the leave of the court, without the leave of the trial court there, and certain other restrictions have been put on the accused. So I think, there's a balanced approach. If there is a serious medical condition, then, this ought to be considered irrespective of whether for what 43D5 says or what other similarly situated provisions in other, statute books placed like UAPA do. So I think there's a balanced approach brought by the Supreme Court today that, on medical conditions, we can very well grant bail irrespective of what 43D5 says.
Right. Sanjay Hegde, coming to you, the top court had earlier also, pointed out and very categorically pointed out how bail needs to be the rule and jail an exception, and that really wasn't the case today. Would you say that those comments the court made that time and what has happened today also, can it be correlated, or should today be looked at as something totally different with respect only to the UAPA?
The Court of Justice call was speaking of bail in general.
Yes, that's right.
Today's bench was dealing with UAPA.
Yes.
Like UAPA, PMLA, NDPS, there are all these rather harsh laws, and UAPA and PMLA seem to have been in recent times been used rather subjectively. Now, you did mention the facts of this case, where there was a meeting where speeches were made, and then the next day violence happened. Now, your viewers must also be told that Mr. Varavara Rao or many of the people accused in this case were nowhere near Pune. Some of them weren't even in Maharashtra at that point of time. Yet the prosecution has made out this case that there was this huge conspiracy, and the prosecution also relies on certain documents which were found on some computers. Now, those documents have, those computers have been subjected to forensics abroad. And there seems to be a case that Pegasus was used to plant them on those particular computers. At the time that the government in Maharashtra first changed, that is when the Aghadi government came in, there was even an attempt on the part of the then Maharashtra government to sort of dilute this case, or even not to proceed further with the case. At which point of time, the central government took over the case through the NIA. These are facts which are there in the public domain. And we can only assume that somewhere in the back of the court's mind, it was also this knowledge.
Yes.
So therefore, those pointed questions to the ASG, who of course had his job to do. As a prosecutor, he was prosecuting to the maximum limit that his brief allowed him. And the court recognized that he was doing his job, and they even sort of congratulated him for doing a tough job. But it said, notwithstanding all your objections, at the end of the day, you have an 82-year-old man. You don't need custody for any further investigation. You've already filed a charge sheet. And this is his medical condition. The Bombay High Court had given him 3 months interim bail so that his medical condition got better. This is not a medical condition which can improve that way. So it doesn't make any sense to put him back into prison at this stage. So the court here has passed an order based on the facts of this one case alone. It has kept it has said that it will not be a precedent. So it has taken all due care and caution. But at the end of the day, I mean, someone in government must answer. Do you need to keep 82-year-old people with Parkinson's inside prison? Why should you send your lawyers into court with what are clearly inconsiderate instructions?
Hmm. Yes, absolutely. And that then brings us to the larger question, which Mr. Hegde, you've raised on several occasions with these stringent laws. And Namit Saxena, if you would like to weigh in here as well, whether it's the UAPA, the PMLA, NDPS, obviously there are so many stringent provisions in all of these laws that a lot of people, including Mr. Hegde, feel that need to be re-looked at.
See, there are two perspectives of looking at it. One perspective is from the side of the state, where, where special circumstances require special, laws or special provisions to deal with certain, accused or certain crime which is, committed. Another perspective is that whether, they should be applied uniformly, across the board on all accused, irrespective of whatever the allegation may be. See, for example, UAPA is also unlawful activities, also terrorist activities, and other, there are other, like in the definition, there are other things also included. For example, similarly, PMLA. PMLA can also be attracted through FEMA or through other, there can be a lot of predicate offenses. So whether there should be a uniform yardstick to apply, or there should be, a complete relook as to how these provisions work. So this needs a larger debate, and I think Mr. Hegde is right in pointing out that that these are laws which have been made by the Parliament, and that there's a burden rather has been shifted on the judiciary, particularly to look out for ways as to how you grant bail in such matters. Like another such such example is where Justice Ramana, without looking at the rigors of 43D5 or UAPA or PMLA, NDPS Act provisions, he granted bail in one of the judgments, saying that if you have been in custody for a considerable period of time, then it itself is a ground, irrespective of whatever provision is there, as a hindrance in granting of that bail. So that this is now another example where looking at solely at the medical condition of the bail without looking at merits of the case, rather clarifying that we are not looking at it from the standpoint of the narration of facts and only on the medical grounds you are granting bail to a particular accused. Now these are ways with the judiciary is evolving itself and crafting itself to to grant bail. But as you pointed out that the general law which is there, that bail is the rule and jail is the exception, that does not squarely apply to cases under UAPA, PMLA, NDPS Act, etc. This is what Justice calls judgment, rather, and Satyendra Kumar Antil also covers that, because he has categorized them separately. So this needs a larger debate as to how are we looking at our criminal justice administration, and particularly where serious offences like UAPA or PMLA or NDPS Act are involved. So this needs a much larger debate in my view.
Yes, absolutely. It does, in fact, need a much larger debate. But Sanjay Hegde, what Namit Saxena was pointing out, the burden is shifted onto the judiciary in terms of, how to whether to give bail or not in such cases. And that becomes the real challenge here, because the way sometimes these charges are slapped on, whether it's the UAPA or the, NDPS or any of them for that matter, that also raises questions. While in some cases there may need to be such stringent laws in place, where it is used and how it is utilized is an entire different question.
I agree on the point that there should be a larger debate. And the larger debate is, what kind of a country are we? Are we a democracy or are we a police state? Because once these kind of laws exist on the statute book, there's nothing which prevents a policeman from saying, oh, this falls within UAPA, that falls under PMLA. We just file a case and lock the guy up. And they then let them run through the courts, run the gauntlet through the courts, as it were, and despair of ever getting bail. If you make laws like this as a country, you will no longer qualify as a country with free citizens in an independent democracy. You might as well be North Korea. You might as well be any other of those tough states, which are tough on anything that they think is criminal. So if you are going to give your government, or you're going to allow your government to pass such atrocious laws, then the judiciary may pick out and may actually be able to, in an extreme situation of an 82-year-old Varavara Rao, finally say, okay, let the man go on medical grounds. But the systematic relief that lots of people who can't approach the courts, who can't approach the Supreme Court, but yet will be under the boot of any policeman who decides to invoke UAPA against them, against the last and the least who are rotting in our prisons. There really isn't too much hope. You say that these laws are meant for terrorists and foreign exchange smugglers and this and that. But you throw the net so wide that you can catch each and every person that you particularly dislike. They need not have done anything further in terms of criminal activity.
Absolutely. All right. On that note, I'd like to thank both of you for joining us on this discussion. And like you pointed out, this is something that requires a larger debate, which we will probably get to at some point.